Okay, so you have dealt with fear, resentment, you have brought in a psychologist, and an employee decides to object to that process. They say, I will not take part in this consultation. This is a sham, and I'm objecting to it. What do you do?
Wow.
Yeah.
That actually happens, Stella. Sometimes they even participate. They'll sit through, but then they refuse to sign everything. They refuse the letter. They refuse to send the minutes. They refuse everything, and then they even send a lawyer with a demand letter, like, you know what, we can't proceed, we can't do BCD and all those things. But as long as the process is fair, the business has to do its business decisions. They have to be implemented. As long as the business is doing the right thing and following the procedure. But now I'll talk about when you know you're doing the right thing, and it's not about this particular person, it's about the business. So you're sure the process is fair. It's just them who are dealing with their emotions. So first, see how to support them. See how to support them. Sometimes they might agree, sometimes they might refuse. I've even seen cases whereby you even offer an alternative job and the person says, I do not want. You even tell them that we have this particular person, they're going to work with you, could be a counselor, could be a coach, they can do your career tools, and they say, I do not want. And they refuse any sort of support that you extend. If that happens, you can't force anybody into a job. Yeah. So still go through the particular process as far as I'm concerned. Write to them, offer, ask them again, take your time. We'll still be here. Make it in writing. We'll still be here and document. We spoke about documentation.
Yes.
All that support that you're offering and they're declining. Keep saying, you know what, yesterday we met, we hope you're still thinking, and if you choose to come back and maybe take a BCD, we'll still be here and willing to support you this particular process.
Fantastic.
So the most important, document, because they might even say they were never invited to some of those processes and meetings and things like that. So do the whole process and still process their dues as per the law.
Can I say something interesting as you mentioned that? My client was served with an application that was seeking to injunct or restrain
him from doing a redundancy.
Exactly. So this particular client of mine had actually issued a notice of intention to declare redundancy and was now in the process of the consultative period, which is a 30 days notice period. And they were served with an application because the employees decided to go in court, to go to court, and seek orders, injunctive orders restraining the company from declaring them redundant. Fortunately, the court did not actually grant those orders, but we were given a date to come and argue it. And we argued and told the court that they are trying to restrain a process that, number one, is not yet complete. They are assuming that they will be declared redundant. And the court cannot issue orders based on a speculation. So it should be, it's not for the court to come and say, stop this process, yet the process has not actually seen has not been seen to its fruition or to the very end. And there's a reason why the process in law can be challenged at the end and not midway, particularly if it's merely speculative. And that's how we were actually able to deal with that particular issue. So even as you're speaking about objecting, an employee objecting, it can go as far as them going to seek an order from the court. And we were lucky that we were before a reasonable court that said, I mean, that is merely speculative. No one has declared you redundant. You do not even know the criteria that they will use because you've just received the notice 2 or 3 weeks. Actually, no, it was 2 or 3 days after they received the notice that they rushed to court. So you can see that that is fear that led them to do that. And the anxiety that comes with doing this. And it goes to what you're saying. Pre-redundancy conversations matter, because perhaps if the pre-redundancy conversations happened in a safe, psychologically safe space, they may not have immediately rushed
to court.
And
I know we also have a case whereby the judge said, yes, hold it.
Yes.
Hold it, but not forever. It's about if they feel they were not consulted for whatever reason. If they have very good reasons, like we feel this has not been done, it is not clear, it is not ABCD, then the judge said, I'm giving you 30 days. Then come back with the following, or after that you can proceed. Because I want to imagine the judge are very contextual. It has to depend with case to case.
Yes.
So there are times that the employees can actually have a reason as to why. And that's why I said you must ensure as a HR or as the business, it's actually fair. You have your substantive reason and procedural process, and it's not about this particular employee, it's about the process. So if you're very clear, it's actually fair and all that, then please proceed. Don't stop your business decisions that are going to affect the sustainability of the decision because one or two people feel like they cannot adhere.
Okay.
Again, it doesn't matter what you do. There are times that you still have employees get very bitter because it's about their livelihood. And that's why you have to always think about not just the law, the human, the business, that tripartite, bring all those together. There are times you do everything until the employee feels very aggrieved and they'll still go to court. They'll still refuse to cooperate in whichever way. But if you know you're doing the right thing and you've done everything to give them the support, and that's the right business decision, please proceed.
And that's why it's called work law in the drama.
Exactly. It's a lot of drama, I tell you.
Okay.
Yeah.
Thank you.